Okay, abusuya be ma kwa ba shonko so e de ba POG Media so. Ya dem be kwa political highway so highway ne de ensem bebre wo so ayen so ya Japan se be me abedwafo no ahu de eko ene de e ba abusuya yem bonwura yensem no yenko eye high court eye NPP ne NDC eye omo kisa akwa pimo e wo high court Supreme Court e order om se omra high court na say court no MB here omo application na we NHS NDC lawyer asori agina ho say masa and case matter my lord, let the rule of law what to prevail and yes adia baby a nyoma ekeka kono ase mo pesa mo chia nyoma bi edema NPP amanyoko na we na judge no so no the lawyer ne kan no na dwen eba afie e kire eye NPP for ne say the omonso ye no enye ade a eto asomo so omonfa omo ni evidence bi omo de be back omo fact no nti abusia high court wo no nyoma ekoso no eho ano aye den yi a enye easy kra no na uti entema ekoso a eye NDC for lawyers ne de omo no bibia akire omo bibia document no omo papers omo asanso show videos akire high court at say omo no omo evidence na eye clear enti no eye high court yet no wa kire NPP for mu say hey omo evidence na omo wo no omo ni facts bia omo de be back enti na busunya bibia e koma NDC amanyoko na amom yanko na yenkokoti ensema ekoso madam ase.
Evidence is on the face of the pink sheet. I have a pink sheet from you as EC, and from EC, the figures on the pink sheet that you've given to me shows that I've won in 31 police stations. And if these 31 police stations is added to the 110, it puts me ahead, and I beat my opponent to 2,352. You know, a gap of 2,352. However, during the collation, you find out that the figures that is coming for the collation are different. So this is what we pointed out, you know, and it's surprising the stance they're taking because my opponent's agents were in the room at the time and they had agreed. In fact, the suggestion, from what I understand, came from them. I didn't initially agree that the 31 police stations be set aside because I knew that this was my numbers. I was going to be disadvantaged, you know. So I mean, it wasn't a case. We still stand that. I mean, if the 31 police stations with the pink sheet that we have given to us by the EC is anything to go by, we would have won the election. We'd won the election, in fact, you know. And if it comes to Kaiko Central, for instance, there are some police stations that the NDC has never ever won in these police stations. This time around in 2024, we won a number of these police stations. Interestingly, whilst everybody is there, pink sheet shows that you won. You come to collation and the figures has been swapped. You know, and so that's the point that we made during the collation. Before the EC themselves, they have their own policies. We are not the ones that decide for the EC what to do regarding declaration. They went in and they did their declaration. As it stands now, that detailed declaration, I think, to be fair, has been done.
That's why it was done at duress.
Of course, I mean, it was never done under duress. I mean, it will require a whole court petition to be able to determine some of these issues that they brought in. But be satisfied, some of you were in court, you heard them. The narrative of duress was largely missing. You know, in our case, for instance, I mean, when my opponent had written to the EC, the letter that was read in court, for instance, he was reiterating to them or affirming that the declaration had been done. He only wanted it to be revoked because of irregularity and coercion. These are two different ways. I mean, if you break it down. So yeah.
Okay, so that is Baba Sadiq, one of the parliamentary candidates whose constituency is affected by this court action, and his lawyers made a submission in court, made a very interesting submission to have in his favor, just so to ensure that they have a decision in their favor. So you could see a lot more people in court monitoring proceeding. Party faithful have all come to the court, and you see a lot of people gather here, and all of the people have also come to. So as you can see a lot of singing from some section, the cross section of the NPP. So that is counsel for the NPP, the Gary Nimakun, who has been ushered into his car. Let's just get closer and see if we can get a word from the Gary Nimakun. Of course. Okay, so let's also hear. Let's hear this.
To save Ghana.
That's the atmosphere on the part of the NPP faithful or supporters who has also been to the court. That is what is also that's their reaction. As you can see, revolution is one thing that also came up in court. So clearly today has been a very busy day, a very tough day in court. The parties have all made their respective submissions to the court. And in relation to the individual submissions that were made, we realized that yes, Sema Central took center stage, Ablekumanov took center stage. In relation to Okaikwe Central and then Techi South, the court, the applicants relied heavily on their processes filed, and the court will have to deal with it as it is. So that is the cheers from the NDC supporters or the party faithfuls who had stormed the court to lend support on what has happened in relation to today's sitting. So as you can see, everything is they are just to tell the world why they have stormed the court. They want their voices to be heard. They want everything here. They want them to be identified that they have also been to the court. That is the NDC supporters who have gathered at the courts to throw their weight and support behind whatever is happening. So it's been a very interesting day, a very long day, a very hectic day, of course. But the court presided over by Justice Forcing Ban Ejepon has adjourned the matter to Saturday, January 4 at 12 noon for a determination to be made. So that is what has happened in relation to what the whole processes have been. Let's get closer to Justice. Okay, so let's just get closer to Dr. Justice Shemsai and get some response from him as far as this particular case is concerned. The fact that the case has come up and then the court has adjourned it. Dr. Justice Shemsai is just around, and then pretty shortly we'll engage him so that he gives us some perspective about what has happened and what we should be looking out for, especially also because next week the parliamentary candidate elect would be sworn in parliament, just so because they take their seat before the president elect is also sworn in at the Independence Square. So submissions made today have been very, very interesting. The local copious legal submissions have been made, authorities have been cited, and of course the court's attention was drawn to precedent decided cases and what a court ought to look at to be able to come to a firm determination in relation to that. Earlier, a preliminary legal objection against the hearing of the mandamus was refused, was overruled, because the court was of the considered view that there should be another avenue, of course, especially so if the election has not already been in the Gazette. There should always be that platform for an aggrieved candidate to raise issues or to file an application, seek for judicial review in the nature of mandamus. So clearly, the law court complex has been very busy. The parties are here. Ibi Bright was present. Rabina Obin was present. Baba Siddiq was also present here, except Mr. Christopher Beyer was also present in court. So all of them have come up in court and they have made their points clear to the court, and the court will now have an onus to make a determination in respect of this very case on a Saturday. So clearly the case has come up, and as you can see behind me, a lot more people have come to the court to make their voices heard, to lend support to their respective parliamentary candidates in relation to this very matter. So if you look at what is happening now, it looks clear that all of them will have to go and make their way back to the court sometime on Monday or Saturday, I beg your pardon, Saturday, January 4, 2025, where the court will be making submissions. So as you can see, few people standing around, looking at what is happening and also having conversations around. And so pretty shortly, we'll engage Dr. Justice Remsai, a senior law lecturer and also a private legal practitioner who has also been monitoring this case throughout from the morning up to this time of the day, so for some perspective and for some appreciation. The police has also not been left out. The police have also made their presence felt here at the court, and they were here to ensure that whatever processes that or whatever activities that are taking place, lives are saved, properties are protected, and everybody lives here harmony and without any issue at all. So clearly that was the reaction, or that was how the situation panned out here at the law court complex here in Accra. So that is what it has happening here. So let me just get closer to Dr. Justice Remsai, who has also been in court right from day one. He seated, monitored whatever was happening, and he gave us some perspective as to what exactly has happened. Now, you were in court, you heard argument being made in respect of each of the constituency. First of all, with Samara Central, you heard the argument that were made. Submissions were made, videos were played in open court. From where you stand, what does it mean to the case before the court, really?
So the Tema Central issue is one of whether or not there was a declaration. I think that was the main thing. And you will see, I think on the 13th, the EC issued a press statement concerning the collation that was happening at the police, police training school. And the EC itself called it a recollation. And in that, you see that the video played showed that there was a declaration of the result. Now, the petition or the applicant's concern was that the declaration was not proper. But that obviously is not a question for mandamus to be. It requires a certiorari. If you allege that something was done improperly, you apply for it to be quashed, not to ignore it and then issue an order for a different thing to be done. That was a fundamental flaw in that particular case. But the other issues are that for mandamus to be, granted, you need to show some things. One of them is that you have statutory duty, which is expressly stated in law. There must be a demand that it should be performed, and there must be a refusal that the demand will not be performed. Clearly, there is no evidence that there is a statutory duty called recollation. Once collation is done, the next thing you do is to challenge it by way of what? Election petition. But there is nothing like recollation. That has been our argument. Secondly, there is no evidence a letter purported to have been submitted to the EC.
So in respect of those letters, what exactly are the letters supposed to confirm before an action of this nature is initiated?
Yes, so those letters are supposed to first indicate that there is a statutory duty, and secondly that they are demanding that the duty be performed. And the EC should have responded or replied to the letters to say that I will not perform it. Then the course of action for mandamus would come to exist. In this case, there is no letter from the EC indicating that they are refusing to perform those functions. And if you look at the posture of the EC during the proceeding, you could see the readiness to perform the duty. So then the question we ask is, why come for mandamus if all you want is for the EC to perform a duty, which they are willing to perform anyway? What is holding the EC? But that is why they are not telling the court the whole truth. They are proceeding on the assumption or on the falsehood that there were no collation, and that was the argument of the applicant. There was no collation. But of course, thankfully, because of technology and video, we have all seen those collations being done. We have all seen the declaration being done. Their problem is that the declaration was not proper. It was not in compliance with law. And our position is that if that is your concern, then what you need to do is not to ask for mandamus, to ask for certiorari right to quash it. And that can be done through an election petition. So you have no room, but the judge disagreed with us and ruled the other way.
Yeah.
And that,
so if you look at the objection point that you indicated, was that this very mandamus application was defective in nature and it was incompetent based on grounds that you felt that a declaration had been made, and so if there's anything you should come by an election petition. The court disagrees with you. The issue about threat and duress and coercion, how does it play in this whole matter?
No, we think that those are serious allegations. Threats, use of force, fraud, those are significant allegations. And even in normal civil rates trial, if you allege such things, we are required to, particularize them, and they are supposed to be tried. We call witnesses, they will be cross-examined, counter evidence will be provided. You cannot do that in this particular process of mandamus. So that has been our concern, that it's as if the case has been converted to an election petition. You could see that when you read even the documentation that were provided, it is clear that you cannot make any concrete decision on them unless you hold a trial, and that trial cannot happen. And of course, it did not happen today because the judge is going to give a ruling on Saturday. So we believe that if the rules the rules regulating mandamus and all the legal principles that we have stated, if those rules are followed, we expect that Saturday will be a favorable outcome for us. And if it is so, then democracy and the rule of law will prevail, because we do not believe that the EC itself has the capacity to determine matters of legality, and by the fact that they are alleging it and we are denying, means that there must be a forum, a third forum for that to be decided, and cannot be decided by the EC itself. So that is why the framers of our laws, the Constitution and the constitutional instrument, were specific that if you have any issue with any election result, you need to what? File a petition, and there's a good reason for that.
So there are those who are wondering what exactly will be happening, or the fate of these parliamentary candidates will be after Saturday, when we know the outcome of whatever will happen. But with this mandamus application, the court fixing to determine this mandamus application, what should the parliamentary candidate be thinking, and their constituent, what should they be thinking?
I think as far as our candidates are concerned, they are not happy with the situation because they have been duly declared, and they should be treated as all parliamentary candidates have been treated. You wait and then you challenge but they are being treated, taken through a process which is needless. Now, on Saturday, the worst case scenario for us is that the court will order a collation or a recollation for that matter. That will still not be able to inure to their benefit directly, because we believe that we have enough, but just that we want the rule of law to prevail. In principle, this process should not have been going through. They shouldn't be taken through this process at all. And I think it should have ended this morning with a ruling, but unfortunately we have to go through and extend their sleepless night has to be extended for another few days. But we are hopeful that eventually rule of law will prevail and the outcome will be favorable, one that will help not just our PCs, but also the country as a whole.
Thank you so much, Doc. So that is Dr. Justice Shremsai. Rabna Obin is also here. He's actually been sitting throughout the court section, and then he has been very forward looking, especially about whatever processes were going to happen or the outcome of ratings.
Okay, abusunya we ne ensema ekoso ewo political highway so NDC lawyer edozi tamakulu ono ena chese omo ye ensencheni ewo high court etese omo ama high court judges no matching omo adwen abefia chese omo che NPP amanyuku ni say masa they have no evidence to back their facts into no NPP for nankasa omo ni so every omo ewo high court omo bianko ya beda masese mo JP ni okoti sa audio edimai POG Media.